The legislature, in creating the city manager, or authorizing the city manager form of government, is put the same authority in law that exists in a mayor form of government, and specifically says that you as a council member in a manager form of government, and there are 52 of you, by the way, may not interfere, shall direct the appointment or interfere with the council or manager, direct appointment or removal of officers, and except for the purposes of inquiry, the council and its members shall deal with the administrative service solely through the manager, and neither the council nor any committee or member thereof shall give orders to any subordinate of the city manager, either publicly or privately. The provisions of this section, again referring to the same law, do not prohibit the council, while in open session, from fully and freely discussing with the city manager anything pertaining to appointments and removals of city officers and employees and city affairs. Technically, under this statute, it's a violation of law for you to talk with one of the road crew members, to call the public works director and report a down stop sign, or call the parks director to say that there's a base missing on the ball field. Is that the way most of us operate in cities? No, absolutely not. It's not a problem in most of our communities for you as a council member to pick up the phone and talk to the police chief about, speeding on Main Street, or to call the public works director about a pothole over on 3rd Avenue. That's what you do as council members in order to serve your constituents. This law isn't meant to address that kind of activity. This law is to prevent you as a council member from interfering with the executive authority, in this particular case, the city manager, by directing particular activity or interfering with the activities of one of those administrative departments of city government. So you can't call the public works director and say, "Oh my God, I want a stop sign up at that intersection tomorrow." You may be able to, but you don't have any authority to, and the city manager or the mayor can stop you from doing it. Here is an MRSC inquiry from back in 1998. May a city council employ separate staff? And the inquiry says it does not appear possible for the council in a non-charter code city to provide for legislative staff positions. Why? Because under the law, the appointment authority and removal authority rests with the CEO. In a mayor-council form of government, the mayor. In a council-manager form of government, the manager. And again, we saw the statute that prohibits you from interfering with appointments or removals from office. It's actually a lawsuit out of Boston a few years ago where the Boston City Council wanted to hire its own city attorney, its own legal counsel separate from the city attorney's office, who reported directly to the mayor, and the court said, no, you don't have as a council, Boston City Council, the authority to hire somebody separately to work just for you.